appeal in the matter of children.
Yes, Miss Mayor.
May it please you, my lord, lady. I appear on behalf of the appellant mother in this matter.
Yes.
My lord, can I start with an apology in relation to a document that was not in its proper format?
Don't worry about that. It was just the pagination missing, wasn't it?
It was, yes, my lord.
Okay.
We did try last night to rectify by
No,
providing...
it's not caused us any inconvenience. Don't worry, Miss Mayor.
Thank you. We have hard copies present if you would wish to have them in hard copy.
Thank you.
My lord, you'll be aware from the papers and from my apologies, I haven't introduced everybody. My lord, my learned friend, Mr. Goodwin, King's Counsel, appears on behalf of the local authority in this matter, and he has with him today a pupil, Rhys Williams. I'm attended by...
And also, I think he's got Miss Allwood with him as well.
No, Miss Allwood is for the intervener.
Oh, so she is.
My apologies.
My mistake. Yes?
I also have in attendance with me Junior Counsel Kirsty Gallagher.
Right.
I make it clear at this stage, and it's not a criticism, but it's a matter of fact that obviously my learned friend, Mr. Goodwin, King's Counsel, was not trial counsel during the course of this trial. My lord, we appeal against the judgment of the court below. We have set out in some detail, and we apologise for that, but it was the only way to try and convey the manner in which the hearing and indeed the judgment making in the hearing involved. We set out in the chronology the various iterations of the judgment that finally appeared. It is dated 3rd of August. It wasn't in fact circulated to everyone until after 9 p.m. on the 9th of August.
I was just going to, if we could just briefly go through that chronology again.
Yes.
It's in your doc skeleton, isn't it?
My apologies, my lord.
It's in your. It is in your skeleton.
It's at A57.
Yes.
The core appeal bundle.
Right. So this tells us everything we need to know about the chronology of about the provenance of the judgment and the other documents. Does it?
It should do, my lord, yes, although obviously we expand upon differences in documents in the skeleton argument itself. So you'll be aware...
Let me just, where the judgment goes, the first draft of the judgment goes out when? The 25th of May.
25th of May, so it's page A61 in that appeal bundle. That was the initial draft text of the judgment, and we didn't feel it appropriate to include that in the court bundle.
No.
Because clearly...
Well, when's it handed down?
The final version, officially handed down, we were led to believe the 10th of August.
Okay, all right. So the request for clarification comes before the hand down.
Not only the request for clarification, but
lots
also,
more. Okay.
Yes.
So then the 30th of June.
That was a copy of the judgment.
Perfected copy.
Yes, it was titled that in the email that sent it out from the court, and we note by way of an aside it was.
And then the same date, further final fact-finding judgment forwarded to the solicitor.
My lord, to assist you in understanding the relevance of that date, on the 30th of June, that was the second hearing in relation to a child who was born post the conclusion.
Why? Yeah.
And so it appears that the judgment was circulated for use in that proceedings.
Okay, all right. But it's still not been handed down at that point.
As we understand it, not officially.
And then on the 14th of July, appendix of agreed note.
We had identified in the request for clarification that the judgment had referred to an agreed note regarding the Part B allegations, or the historical allegations. We had identified that we had not received that, and in fact we did not receive that until the 14th of July. So not only did it not accompany the 25th of May, but it also did not accompany the 30th of June version of the judgment. That now forms an appendix to the...
Okay, so the document, that document is one of the annexes, is it? Or was it amended again?
It is one of the annexes.
Yeah.
I don't believe it was amended between the version that appeared on the 14th of July and the version that's annexed. However, it was retitled because it was not a document that we had been able to agree. Does my lord wish me to go into detail as to how that document even came into...
No, I'm just trying to get the chronology of all this clear at the moment. So I'm on to the next page now. And then we've got there was a court order on the 19th of July specifying a date when the judgment will be handed down and giving direction about applications for permission to appeal, which were complied with on the 25th of July, yes?
Yes.
Then there's another hearing.
So the court directed that there should be an oral hearing in relation to those applications for permission to appeal. That oral hearing took place on the 26th of July. There were difficulties in that the local authority at that hearing were not represented by trial counsel and had not responded in writing to the documents provided by the mother, father and intervener. And having heard oral submissions from those who were present at the original hearing and present at the permission to appeal hearing, the learned judge then decided to delay handing down of the judgment and to delay giving a decision on the permission to appeal application.
All right. Well, I'm going on. I don't want to take too much time with this, but it's a very convoluted history.
Yes.
Okay.
So, my lord.
So, can I just ask this about Annex 1? Am I right that the final version of that was not the one that originally circulated?
That's correct.
How many times was it amended?
In the document itself?
No, on how many occasions was it amended?
As we understand it, we had the original clarification and amplifications sent out with the 30th of June judgment, and then it was amended to be sent out with the judgment that appeared on the 9th of August.
Okay, so once.
Yes.
And am I right that paragraph 10C was not included in the original version circulated and only added after submissions were made for permission to appeal?
Yes, and that is not the only, we say, major amendment after the permission to appeal. In my learned friend's skeleton argument on behalf of the local authority, he refers to the fact that the judge has, when using the term accident, prefaced it effectively by an accident that is as a result of deficient parenting. The use of any suggestion of deficient parenting in connection with accident only ever appeared in that final version of the judgment.
Well, I think for my part, and I haven't obviously discussed this with my lord or my lady, I think have we got the original version of the clarification document?
You have it in the way that it appears in the 30th of June judgment, if you bear with me one moment, which is in the supplementary bundle.
I've not spotted that.
At 273 is where that judgment appears.
310.
Page 310. Okay. So that's the original version of the clarification document.
Yes.
And just so I've got to make sure I'm absolutely right about this, there was only one occasion when it was amended. It was amended in various ways, but there are two versions of it. This version and the one in the...
Yes.
Done. Okay. All right. Thank you. Right.
So, my lord...
Thank you for that.
So,
now, what's the structure of your submissions, please?
my lord, the structure of our submissions are these. That the court below failed to properly consider the actual mechanism for injury. And by that we refer to this idea of it could either be inflicted injury or accident. And I choose accident at this time because we do say that the number of times that the judge had the opportunity to correct the judgment prior to the 10th of August lead us to believe that it can only be explained that she fell into error by thinking that even an accident that was not as a result of parental deficiency in some way would be sufficient to cross threshold, because that is entirely the way the draft judgment was expressed. After clarification, the 30th of June perfected judgment was expressed, and it is only after then both written and oral submissions that she in any way brings an attribution to lack of parental care to the idea of accident.
So, are you happy if we use culpable and non-culpable?
Yes.
Or do you think that is imprecise? That's I think that phrase is that maybe Mr. Goodwin's phrase. Are you happy to use that phrase?
I'm happy
shorthand?
to use it as shorthand.
So,
my lord.
You're saying that it was only in the very last iteration of the correction document that she distinguished between culpable and non-culpable accident, and up to that point, everything that she sent out, the judge sent out, was on the basis, or proceeded on the basis that a non-culpable accident was sufficient to cross the threshold.
I'm going to be careful in my wording. Her wording used was accident. She had not defined it.
Okay, she had distinguished between culpable.
Yes.
Yeah. So it up to that point, her finding was that any form of accident, be it culpable or non-culpable, was sufficient to cross the threshold.
Again, I'm going to be careful, my lord.
Okay.
She didn't define it. She simply referred to accident. Okay. And we, in our clarification document, pointed out that it didn't appear that formulations that appeared throughout the judgment met the Section 31 criteria, in particular in relation to attribution, to a lack of reasonable care by these parents. And indeed, in the oral submissions on the application for permission to appeal, there were exchanges as to whether, in fact, accident could ever cross threshold. And so I'm careful to not put any gloss on the way that she, in fact, described it in her judgment up until the point that we see the further explanations on the 10th of August. It was simply referred to as accident, and that was why the query was raised as to how could that possibly meet threshold. And indeed, the examples that are then given by the learned judge in her final 10th of August version of judgment were these, effectively that a culpable accident might include the example that she gives of the boiling saucepan and a child being able to reach for a boiling saucepan, which had absolutely no relevance to the case that in fact was in front of her. And then the second, potentially more relevant, was where she referred to the evidence in the case that the car seat had the straps missing. We raised 2 points in relation to that. It had always been the evidence of the parents, and is contained within the statements, that on the day, so the 8th of May, where there is this car journey that is referred to in the judgment and the taking to the market, the straps of the car seat had been removed to be cleaned because they were dirty, they were soiled, and they had not yet dried. And the mother gave the example then of the car seat being strapped into the car by the seatbelt and her also sitting with it. There was no other exploration or evidence in relation to what might have occurred as a result of those car seat straps missing. And it can only be of relevance to her Honour's determination if in fact she in some way is accepting, although she appears to reject it, some accident with the car seat as being responsible for the accidental injury to the child. And so we fail to understand how it is that she has used that example in connection with her explanation that there was some parental lack of care enabling her to make a finding of culpable accident, effectively as she does in the final verdict.
Hasn't she found that, looking at the evidence, hasn't she ended up in this place, looking at the totality of the evidence, and in particular bearing in mind the dishonesty and lack of frankness of the parents and the older child, 3 adults, that she concludes that the injuries were sustained either through being inflicted or through a culpable accident. Isn't that where she's ended up?
That's where she'd ended up in her reasoning in the 10th of August judgment. We obviously have said the manner in which she gets there gives us very grave cause for concern as to whether in fact, realising an error, she is using the reasoning, if I can be very colloquial, to plug the gap, rather than that actually being part of her exercise at the time she was sifting through the evidence and reaching her conclusion that there was sufficient here to cross threshold at the earlier stage. And so, although we accept that corrections can be made to judgments afterwards, what we say is impermissible is effectively to rewrite what was your thought process at the time of announcing your decision the first time round. And so we can only say that we assert she fell into error at the time of the 25th of May, but more importantly at the time of the 30th of June, when she responded to the request for clarifications. And what she has done is retrospectively correct the wording, and we can have very little confidence that she was in fact applying the correct test at the time. What we also say, my lord, is that in reaching that final position, the consideration in her judgment of those 2 alternatives, inflicted injury against culpable accident, is not adequately reasoned. We actually do not see in our respectful submission any consideration by this judge in her judgment about why she leaves in inflicted injury as a potential cause, other than the parents haven't told me everything. Because there is no analysis at all, save for positive comments in the early stages of her judgment. And if you bear with me one moment while I find those, Appeal Bundle A111, where she puts background, paragraph 8. AB is a little boy who is much loved by his family. It is quite clear, having heard the evidence of the 3 adults who are party to the proceedings, that he is a cherished, adored little boy. She also subsequently makes a comment in relation to the mother about her attentiveness to the children, but she uses that effectively to indicate that is why this mother would have checked this child's head at an earlier stage. So there are positive parenting attributes there, and we see nothing in her judgment as to why it is she leaves in for account inflicted, and I think her phraseology is occasionally deliberate, inflicted injury. And so we say there's even an error in the balancing act that she's done at that stage in leaving that as an alternative.
Well, the medical evidence left it in, didn't it?
My apologies, my lord.
The medical evidence left it in.
The medical evidence did, but without being trite, it's not for the experts, and the experts themselves were unable to determine between inflicted and accidental, they using the accidental not only to convey culpable but also true accident, because this was a mobile child, and it's seen from even the judge's summary of the medical evidence, a mobile child who could, in a number of different ways, generate sufficient forces himself to create the forces necessary for the fractured skull. And so we say there's even an error within that, in the way that she has reasoned her judgment.
Miss Mayor, isn't it a bit having your cake and eat it to suggest that the judge was in error, that the analysis was lacking? Because as I read the judge, and we can quibble about how it was expressed, what she was really saying is she wasn't given any help at all by anybody who was in that house at the time who knew what was going on. Everybody was lying. So she had to do her best.
As we acknowledged in our skeleton, there are obviously always problems with an appellant where a court has made a finding that the adults involved have not been truthful. But again, we have to say that the analysis of what the impact of that is on her judgment is insufficient. It's almost as if she has simply indicated these adults, not just the parents, have not given me a full account of that evening, and therefore, and we say that's insufficient.
But she has. I mean, there is a step in there. She says they're all lying. I can't rely on anything they say. She directs herself on Lucas. She draws an adverse inference, as I understand it. They must be lying because something untoward happened. And isn't that why she says there are two possible explanations? Either it was an inflicted injury, or it was a non-accidental. Sorry, it was an accidental injury, but one that was due to the lack of reasonable care by the parents. Because if it was an ordinary injury for which there was a reasonable explanation, these parents wouldn't have needed to lie, but they have all lied to me. So that's where she gets to. That's where she gets to, isn't it? It's the inference.
She may, but again, we say she's got there in an impermissible fashion. So, for
Can I just be clear with this? You're focusing on the way she got to the final.
the way she gets to her judgment on
Yes.
the 10th. Yeah.
Okay. Do you accept that as it stands, her finding is sufficient to cross the threshold?
For which child, my lord?
For the let's start off with with IB. If we take it as just focus on her ultimate decision, do you accept that there was sufficient to cross the threshold with IB?
My lord, I'm going to dance a bit on a pin and say, if it were properly reasoned, yes. If a judge comes to a conclusion, properly reasoned, that there are only two explanations, that she has properly rejected pure accident, if I may use it that way, has properly dealt with why inflicted injury in all of the circumstances of the case, not just in relation to the fact that the medical evidence may support it, but in all of the circumstances of the case, remains one of those two findings, and that culpable injury remains only the other. If properly reasoned, I do not think we would be here on an appeal. And it would
On IB.
On IB. I think I have to accept that, in the same way that my learned friend has accepted that her original iteration
Didn't pass muster.
Yes. But we say that there are a number of reasons why there has to be a question mark about that.
So going back to my point, can we go into the if world, the hypothetical world, on your case anyway? Would you accept that it was open to the judge to draw an adverse inference of the sort that I have indicated? In other words, everybody here is lying. They can only be lying for one reason, and that is to cover up something culpable that happened in the house. And that's why I conclude that either this was an inflicted injury or that this was a culpable accident.
My lady, I'm sorry to not just simply say yes to that. One of the things that you have to consider when we're dealing, I've dealt with inflicted injury and why we say her reasoning on that is insufficient, but we also say she fell into error in rejecting the pure accidental explanation because she effectively tied to the parents' explanation of accidental that they had not proven pure accident on the balance of probabilities, which is reversing the burden of proof. And so the question as to is lying sufficient, the answer is not if you are also applying other impermissible tests. And we say that's one because, in fact, nowhere does she grapple with the idea that one of the reasons why the evidence that she was given might appear to be a lie is that one out of the three adults, let's just, for example, pluck the intervener as being not a parent. One of the three adults either witnessed an accident or is responsible and does not tell true information to the other two adults. And therefore we have to urge against the idea that it is simply enough to say they're all lying without a more detailed analysis of how you reach the point at which you say that lie enables you to come to the conclusion that the mother witnessed something and has chosen to cover it up. And it's when you get to that sort of lie that that may be sufficient.
Well, I mean, whether the mother witnessed it or not, I mean, the judge just said, I don't know what was going on, but all I do know is these three are all lying to me.
Yes, but we say she hasn't gone through a proper analysis of what may be the driver of the incorrect information before concluding that it is a lie. A parent who did not witness and was not told the truth may give a version of events to the court that is entirely true, but appear to be a lie unless she does that analysis. She just misses out stages that we say are essential.
Well, didn't she say, I simply can't say because of the degree of dishonesty? And that wouldn't stop the threshold being crossed, would it?
My lord,
the
again.
threshold is care received not being what would be reasonable for a parent to give. And that would, if that's sufficient to cross the threshold, it may all come into the equation at welfare stage, but it's sufficient to cross the threshold, isn't it?
My lord, only if it's reached in a permissible fashion, and that includes not putting a burden on the parent.
Well, yes. Can you finish your question? Can I just pick you up on that? Where in the judgments and annexes and the proliferation of documents that we have from the judge, where do you say she reversed the burden of proof?
Will you bear with me while I turn it up in my skeleton
course.
argument, my lord? So, my lord, we deal with it in ground 2, which is at
Yes.
paragraph 76 of our document.
Yeah.
And it is at the para 12 annex 1 clarification, which I believe is at core bundle 154.
Para 12.
Bear with me a moment. Will you just give me one moment, please, my lord? Yes. Paragraph 12. I've not been able to conclude which of the three adults deliberately inflicted the injury, if that occurred, because the adults have not been honest about their knowledge of the circumstances, nor how it occurred for the same reason. Nor can I rule out the possibility that the injury occurred as a result of an accident. I could not make a finding that that was so on the balance of probabilities, because the adults have not been honest. So that appears to be indicating that for the parents' explanation that this was a, my phrase, pure accident, they would have to establish that on the balance of probabilities. And then she goes on to say, the evidence I heard in its totality was not sufficiently reliable or credible for me to make that finding. So if what she was approaching was either infliction or culpable accident was crossing threshold, but pure accident would not. We query why it is that she is saying the parents have not proven that pure accident. She doesn't use the word parents, but could not make a finding that that was so on the balance of probabilities.
Accident must be culpable accident, mustn't it, in that sentence? Line 4.
Yes, but if you look, my lord, I think that's one of the ones. Sorry, my apologies.
Line 4 of paragraph 12.
12.
She must mean culpable accident, doesn't she?
She must mean it, yes. But that's one of the ones where it wasn't corrected even in the final version. No, my apologies. Nor
No,
can
I
I
think
rule
it
out
means-
the possible. No, I know
the
the
thing.
My apologies.
She's
I'm
just
really-
saying I don't know because I can't put any weight on anything these three tell me. I don't know what happened. She's saying in terms of their explanation being reliable.
My lord, that misunderstanding of mine goes to what we say is a demonstration of how the way in which this judgment is reasoned in fact leaves question marks as to what it is she has or hasn't found. We read that as accident in the sense of accident, not culpable accident.
No, I read it that way too.
Okay. Well, it's interesting that I didn't.
Yes, and I'm afraid that's part of our problem, is when you receive a judgment written in this way and you cannot understand precisely what it is that the judge has determined and how that determination then crosses threshold either for the subject child IB or indeed, and more importantly perhaps in later arguments, in relation to the other children who range in age up to age 16. And so that's why I'm rather hesitant in simply agreeing that these parents lied equates with effectively sufficient reasoning for saying that's why it has to be either inflicted or culpable accident, and therefore for IB threshold is crossed.
So I think where we are is that you would accept as a matter of principle that if you're faced with lying witnesses, you can draw an adverse inference against them. But you don't think, in this case, if the judge did draw such an inference to conclude that they were lying to cover up, that was a fair inference. I think you say that wasn't fair on the facts here, but in any event, it wasn't properly explained by the judge.
Yes.
So that's really the issue for us, isn't it?
Yes.
Is whether it was open to her, and if it was open to her, whether she sufficiently explained it. But that's what she was doing.
Yes.
Right.
My lord, I think really trying to keep it as narrow as possible. The two other main points then are, let's deal it with in the way in which she has dealt with it. The Part B allegations and precisely how those are dealt with, and whether in fact they should even have been allowed to be before the court in the format that they were, and then the gathering up of the findings made on Part A and Part B to then influence her determination without, again, we say, adequate explanation at all. That those findings meant that threshold was met in relation to the older children who had not, and I'll put it this way, who had not themselves suffered harm. We know that one of the admissions in relation to the Part B allegations is the slapping of child R, but that was in 2017, an exceptionally divorced in time, we say, from the is suffering element of the threshold. Risk of suffering, obviously, predicts a future state, and we'll return to that if we need to in a moment. it also became very difficult to follow what was being said by the judge about the is suffering emotional harm of the elder children, those above IB, based on the parents' lack of honesty. Because it's difficult to see how that could have bitten at the time of the initiation of proceedings if what she is relying on is her determination about lack of honesty of explanations given surrounding the events of IB.
So where do you start? Where do we start in this? Do we start with the findings document? It's what she actually found.
Subject to the caveat, as ever, that the findings document only appeared for the first time after the permission to appeal written and oral applications. Up until that point, we were having to try and extrapolate from her judgment, the 30th of June judgment, what she said had actually been found.
Did the judge produce the findings document? Or
She did.
It wasn't counsel?
No. That was seen for the very first time when it was circulated after 9 p.m. on the 9th of August, before it was said to be handed down officially on the 10th of August.
So it only appeared on the 10th of August, drafted by the judge, after the permission to appeal application.
Yes.
Okay. Well, subject to that caveat, are you content to look at it?
Yes. The findings document is A240.
Mm-hmm.
If I start at A243, paragraph 17, which is in relation still to the finding of physical harm, we say it's not permissible simply to have a finding in relation to a child of IB's age that may include culpable accident relevant to a child at IB's age, and without more, to use that finding to cross threshold for significantly older children on the basis of physical harm, even on the likely to see.
So the factual basis is the lowest finding that she was making, which is culpable accident.
It has to be.
Culpable accident to a baby. On the basis of that finding, it was, you say, not open to her to find that the older children were likely to suffer significant physical harm, or not sufficiently reasoned, or both?
I'd like to say both, but I think again I'm going to be driven to there is no justification given within the judgment that explains how she extrapolates from one to the other. And in the absence of that, we say it's impermissible. It's not permissible just to make a jump. Injury, therefore, risk of significant harm of physical injury to the older children whose circumstances are unique to each of them and completely different. Particularly where you do not have, in the analysis of reaching the determination of injury to IB, any explanation about family circumstances, risk factors, or any matters such as that. I accept. Obviously, that's because she has simply referred to the fact of the parents lying. But it's missing.
At the risk of being a scratch record, and I'm very sorry.
No.
But if when she talks about parents lying, what you should really understand is what she's saying is, and I'm drawing an adverse inference against them because of their lies. And the adverse inference is that something dreadful happened in the house. Don't know exactly what it was, but the injury was culpable in some way or other to IB. Just to follow through the thought process, what do you say if the point is made against you that adverse inference was that the parents wouldn't seek help, they'd just seek to cover up, because that was what was going on in that house, and that's what put the other children at risk?
We have to take issue with the idea of wouldn't seek help, because although she makes a finding of delayed medical, we're talking about a matter of hours.
Yeah.
And so we say it wouldn't be right for her to draw on that finding, that interpretation, that there may be an injury to another child, that this attentive mother would not eventually, and we say pretty rapidly, draw to the attention of all necessary medical sources and indeed beyond. And in fact, the whole history of the case, if the court were operating on the Part B historical allegations in the way that we extrapolated from the papers, is that this family cooperates with authorities, with police, with local authority, works with them, allows them in.
Well, that's
not what the judge found.
The judge found the contrary.
Yeah.
But that's what she found, that they lied to her in relation to this one event. And I have to accept that. But in terms of the extrapolation of they would not seek help, we say that can't be reasoned.
Maybe I overstated. Maybe that I used rather baggy language, and I should tighten up. If the adverse inference was that the parents had failed to acknowledge that the injury to IB had a culpable source, culpable cause, could the judge not extrapolate from that to say that gave her grave concerns about the safety of the other children? Because if they were at risk of injury and the parents not acknowledging that.
I suppose I still become caught up on the extrapolation of a physical act or physical accident that is sufficient to injure a child of IB's age could necessarily pose a risk.
Does it necessarily pose a risk? What am I looking? What was the judge looking at?
Real possibility.
Real possibility.
Real possibility.
So yes, again, I'm sorry, it's my bad use of language this time, but there still has to be an element where it can be transferred, and I'm going to take at its starkest extreme, to the child H, who was 16 and who had voted with his feet about going home.
So you'd say it's not a fair extrapolation that you cannot get from her conclusion, if that's made out, that of what happened to IB.
Yes.
That can't extrapolate to the other children reasonably here, you say?
Yes.
What I wonder about paragraph 17 is what is it doing there at all? Because in order to decide if there's a likelihood of significant harm to the other children, or to all of the children, you look at the totality of the evidence.
Yes.
There's,
and it appears halfway.
CBT, etc.
Yeah.
And at paragraph 24, the judge makes the ultimate finding.
Yes.
Which, if 17 wasn't there, obviously that your point about 17 falls away, because on one view, the judge's finding about likelihood of harm was based on the totality of the evidence, not just her finding about IB's injuries, but also about these findings about Part B.
But again, I'm afraid we take issue as to whether the findings that she explicitly says she has made, in the context of what she explicitly says she has not taken into account from Part B, would be sufficient to found that physical
Okay,
evidence.
well can we just, okay, the physical risk.
Yes.
Well, so what this is my summary of Part B.
Yes.
Bear with me and see if you think it's right. You'll probably agree, I know what you're going to say, Miss May. There are going to be some caveats, but first of all, there were 2 established incidents of violence. And I hope that the family members are in court. I hope they understand. This is just the basis for an argument's sake.
Yes.
2 established incidents of violence. As set out in paragraph 18.
Yes.
The finding that the mother had refused further police involvement. Paragraph 19.
In relation to the 2020 incident.
Yes, yeah, right. The parents' minimisation, the judge's finding, of the incident of domestic violence, also 19.
Yes.
No, yes, 19. And also the lack of a clear understanding. The parents don't have a clear understanding of domestic abuse and its impact on the children. Right?
Yes.
And then the finding in 23 about difficult issues in the home being addressed in the family, even if that means professionals are given inaccurate or misleading account, and all the findings A, B, C there.
Yes.
So those are the findings on Part B. Paragraphs 20 to 22, as I read it, aren't actually findings.
Yes.
So you might say, what are they doing there?
Yes.
But I think the findings are as I've summarised them. And if that's right, plus the finding in respect of IB, if that's right, isn't that sufficient to cross the threshold for all of the older children?
If we are looking at the findings, my apologies, those established incidents in the context of the evidence, total evidence in the case, we still raise the issue as to what we had set out in some detail in what was referred to as the opening note on behalf of the mother, which was also then agreed by the local authority in terms of the context and background to those Part B allegations. So November 2017 and February 2020 are divorced in time from the issue of proceedings in relation to the May 21 event. The February 2020 maybe not so far back, but the 2017 one. But in relation to both, the local authority had been involved and had determined not to take proceedings in relation to both of those on their assessment. And so we say that has to be factored in as well, particularly in relation to the slapping of the child R. I don't demur from the description of it of a incident of violence. However, it is not a incident that itself resulted in significant harm to the child.
Am I right the mother left the home as a result of it?
Yes. That there were various family arrangements not imposed on them by court orders, as a result of which the local authority then, certainly after the November 2017 incident, closed the case. The 27th of February 20 incident involved the police, and my Lord's reference to the mother not wanting the police involved any further is correct, but the local authority also had a role and did not thereafter.
What you're doing is you're picking holes in the individual ones, particularly in historical ones, but it's very common, isn't it, in these cases, in child protection cases, for the court to to rely on historical matters that taken individually didn't, as a matter of fact, lead to care proceedings being taken.
My Lord,
You have to look at the totality of the evidence.
you do have to look at the
Now.
totality, and you have to, I'm afraid, look at that totality in its context. The mere fact that, as a matter of principle, a court can look back at previous incidents and say that they do add weight is not so applicable in this case, and it's the reason why we did such a detailed document at the outset. I say at the outset, it was halfway through the first week because of the way the evidence was coming in, was to say this is not simply a local authority has overlooked or ignored or been unaware of historical, long time ago matters that should now be taken into account. They made decisions based on their assessments at that time that there was no evidence of significant harm. There was only one period of child protection planning, I'm going to say. I'll ask my junior to check as to whether in fact it was child in need planning. But it never even made it to pre-proceedings, and it is not because the local authority were not aware, not only of the incident,
No,
but of the
just so we know.
potential...
You mean it never got close to care proceedings? Never got...
Never.
No. Right.
And so that's why we say in this case, we do say there must be greater care taken about the context of that. And
well, isn't that just a quarrel with the judge's conclusion rather than a suggestion that she ignored a factor or failed to take it into account?
My Lord, I'm sorry, but what we've effectively argued is that by, and I'm sorry to go back in time to explain it, by allowing those contentious allegations to form any part of the fact-finding hearing, she has impermissibly allowed herself to be swayed by the fact of the allegations as if it adds weight to her findings of risk of harm.
Well, you're now talking about the fact that she expressly excluded. So, what can you point to show that she added weight to it? And she took into account at all. She expressly excluded all those matters from her consideration, from her findings. So why do you say they've come in by the back door?
Because of the lack of reasoning and underpinning of the jump that we've been talking about, from risk of harm to IB, to risk of physical harm to the elder children, to the lack of acknowledgement that these two matters that she now relies on from Part B are within that context that I've explained to you about this family cooperating, putting their or accepting arrangements without orders where the mother removed herself from the house and worked her way back, that she has simply herself isolated those and regarded them as being sufficient without more to underpin the findings of risk of harm. And we say even with the real possibility test, there must be acknowledgement of the context of those findings, which isn't there. And where we're looking at two particular incidents which in and of themselves, we say, do not demonstrate a risk of significant harm, because that is another element of the statute. It's not sufficient just to say there's a real possibility of emotional harm. There has to be that degree of significance, which we say is not justified by the findings that she makes. My Lord, can I assist you on other matters? I think.
Are you pursuing the case management point? And what Mr. Goodwin says is it's academic. I mean, he says more than that, but that's one thing he said.
My Lord, one of the things, and again I'm going backwards to explain it, that we indicated to the court below, taking it in reverse order, was that we wanted to be able to leave open, if an appeal was necessary, the structure that that appeal should have. So we didn't want to be met with, but you did not appeal that case management hearing. However, going the stage further back, we do say that she was wrong in leaving those allegations open to be considered in the context of the assertions made by the local authority, which were that without proving the truth or otherwise, the local authority would be entitled to invite her to find that the children had retracted effectively under pressure from the parents, or that without proving the underlying allegations that there was a history in this family of use of physical abuse effectively. They had no place even being allowed to be run if the court accepted the premise that you do not act on unproven allegations, because they carry with them a necessary element of, well, they must be true in order.
But she's not a jury, is she? I mean, your concern is prejudicial. But she repeatedly warned herself about all that, didn't she?
She may have warned herself about it, my lord, but in the context of allowing them to go forward, we find it difficult that she had actually grasped what that warning entailed.
And it's a case management decision, isn't it?
It is. And it's a case management, I know my learned friend categorises it differently. It's a case management submission that did have a massive impact on time and resources.
Well, that doesn't give you, that's not a ground of appeal, is it?
No. We were saying that she had failed to apply the right criteria when considering on a case management decision whether it should go forward. It caused tremendous difficulties, as you saw from our chronology, with the late filing by the local authority, who up until that point had not really supported their approach to those past allegations with any evidence in terms of witness statements from the people who were relevant. So we were faced with a flurry. I think it was going to be something like 24 additional witness statements between the week before the trial hearing commencing and during the course of the trial itself.
Well, I can see that could be difficult, but why does that give you a ground of appeal?
By itself, it doesn't, my lord. I'm just, again, putting it in its context. We just have a sense of unease because of the lack of explanation and reasoning as to how she jumps from one position to another, and from the way that she repeatedly referred to the Part B allegations being taken in the context of Part A and vice versa, that she has in fact been swayed by the mere fact of the allegations as giving weight to her eventual overall findings, both on physical harm, risk of physical harm, and emotional harm. Would you bear with me one moment, please? I can assist.
Can I just ask, broadening it out a bit, if I may? First of all, so far as the family are concerned, I'd like to know a bit more about how all the children are and where they all are.
Yes.
Because there's been a big legal argument, and I'm very interested, for my part, in knowing how the children are getting on. There's been another one since the proceedings
my
started.
lord, they are, as we've indicated, the eldest child, in fact, returned home during the course of proceedings.
Age.
His age, or was at the relevant time, 16.
I've left my... sorry, I've made a note of all their ages, and I've left it somewhere else.
Yes, so
He's returned home.
he returned home in November 21.
Am I right that originally the parents moved out and family members moved in?
Yes.
But that didn't last very long.
No. I say
So-
yes. I may have
Well, I
got
read
that
that
wrong.
somewhere.
But
So tell me where they all are now.
yes. R, the 13-year-old,
Yeah.
is with a family placement.
Right.
S, the 8-year-old, my apologies, is in a family placement.
Same one?
I'm just trying to check. I think yes. The 6-year-old,
Yes.
is in a different family placement.
Which is the one, I with this particular need, is that right?
Yes.
Thank you. I think Miss Gallagher's got all these at her fingertips.
She has, and will no doubt be gesticulating behind me.
Yes. So eyes, so they're in different placements. No. So far they're in different placements. Well,
A, who is the third girl,
yeah.
the 5-year-old,
Yeah.
is in a family placement. All of the 3 girls are in the same family placement.
That's R.
That's
R, S,
S and A. In family placement 1.
Yes.
Right.
And then I, the 6-year-old, and IB
Are together.
are together in
family
family
placement
placement.
2.
And then I'm afraid we also have to add into that
Why?
Y, who is also in a family placement, but totally
how old is
separate
Y
from...
now? Y is little, isn't he?
6 months?
Y was born in June 2022.
6 months.
So she's been away for the whole of her life.
Okay. And is
Based
she,
on-
6 months, and is she in family placement 2 or family placement 3?
Family placement 3. Now there has been, because I think my lord had asked at an earlier stage about where the proceedings had reached
Yes.
and where the evidence was. So can I just give you a matter of timetabling? There has been provided an independent social work report, which I think came in the last couple of days,
Right.
which makes a particular recommendation. But the local authority evidence is not due until the 6th of January. The parents' evidence is due on
Okay.
the 20th of January.
Local evidence 6th January. Parents
20th of January. The Guardian the 3rd of February. And then it is only currently listed, as I understand it, for an
Right.
issue resolution hearing on the 9th of February.
Before Judge Tucker.
Yes.
Okay. Do you want to tell me what the ISW report says?
We understand that the ISW...
Have you seen it?
Yes.
Your client's seen it?
I believe our clients have
Your
seen it. I'm
client,
hoping, yes,
yes,
I can see
yes.
others nodding. It recommends rehabilitation to family in a staged way.
For all of them?
Yes.
Can you tell me what contact? The contact must be pretty complicated.
I'm sorry, my lord, I certainly would need time to work
Yes,
out current contact arrangements.
Well, I mean, broad terms, I presume the parents are having contact.
Yes.
Are the siblings having contact? I can imagine it's a very complicated timetable.
I think it may all be, all at weekends and all together, but I'm just checking with my learned
Right.
junior.
Right. So, the family... I'm sorry to ask these questions.
No.
I think it's important, actually, so that we understand exactly what's involved. So is it supervised by the family members that they're placed with?
Yes. I'm not sure whether there's ever a time that social workers pop in. It doesn't look like it.
And although she's not part of this case, I'm anxious about why. Have the parents had regular contact with Y?
I'm sorry, my lord, will you give me one moment?
Of course. Yeah, if Miss Gallagher wants to tell you, Miss Gallagher can tell us rather than... Miss Gallagher, your moment has come.
Sorry, my lord. I was just double checking, but as I understand it, with Y, there is an additional contact just with Y, but Y also then joins the sibling contact altogether on the weekends as well.
Okay.
And why is a boy?
I said, I apologise. Sorry. Okay. Now, can I ask one other, turning to something else, general topic. I can't remember seeing a judgment with 7 annexes before. Is that something which is you're coming across in other cases? Not necessarily 7, but a number of annexes.
No.
I know there is a practice of attaching a long document of setting out the law.
Which I think the Court of Appeal has already commented.
Yes, which you all settle, and judges commonly attach it to their judgments. That's a practice which is.
My Lord, I can give you
common,
the impression that we had as to why it was in this particular case that we have that. It's not something that I have come across. I don't believe it's something to this.
Or I've come across it in other cases.
But certainly it appeared to be as a result of the points that she was addressed at the oral permission hearing.
Well, there's no. Sorry, the legal summary.
No, my apologies. The 7, the totality.
Okay,
You'd asked
right.
me whether we had come across.
But the practice of attaching a legal summary.
That is a common thing.
It is. Okay.
And obviously we made comment about the fact that none of that was extrapolated into the judgment, and that may be why
Yes.
there were errors in her approach, if this court accepts our argument on those errors.
Right.
Can I assist you any
But
further?
the further and better particulars, that's a novelty as far as you're concerned, when she gives further reasons.
I have to say, my lady, even after having addressed her on the permission application, whilst we might have anticipated that she would have provided what her findings actually were, because we obviously addressed her on the fact that it was difficult to follow what her findings were from the judgment. What we hadn't anticipated was the amendments to the clarifications and the additional paragraphs to the extent that there were in the judgment. And that may be why, certainly insofar as our skeleton argument is concerned, there are times when it is itself a little difficult to follow, it having been prepared on what we had understood to be the perfected earlier judgment of the 30th of June, and we then had to amend it in the light of that later document.
Can I just say, and I'm sorry if I've missed a stitch here, but you had the PTA oral hearing.
Yes, on
And-
the 26th of July.
And then did you get an amendment in the judgment as well as Annex 1?
Yeah, I'm going to say yes, my lady, because there are footnotes at various stages where she indicates that they are added after the permission to appeal. So yes, it wasn't just the provision of annexes. Certain paragraphs, and I think I'd mentioned in relation to the phraseology deficient parenting.
Yes.
Okay. And then 2 versions of Annex 1.
Yeah, I mean, asking for clarification, further reasons, has become very, very common, and we've commented on that in other cases.
Yes.
Okay. Anything else you want to ask?
Thank you very much.
Thank you very much, Miss Mayor. Yes, Mr. Goodwin. Oh no, sorry, Miss Atwood.
Yes, sorry, I've just dropped my phone, my lord.
Forgive me.
My lord, I represent the intervener in this matter.
Yes.
And to set out the structure that I will take, it's very brief. It's in relation to the intervener and in relation to the Lucas direction that she made. In terms of the judgment, paragraph 74 of the judgment.
Okay.
The supplemental bundle.
Supplemental
No,
bundle.
core
Sorry,
bundle.
the core bundle, yes. Paragraph
74. Okay, so that's on page 133. Yes.
She says that in general, AQ's evidence was
Yes.
given orally in an apparently open and credible way. Nonetheless, there were aspects upon it of which I was not confident. It's important to note, my lord, at this stage that at the outset of the hearing, the court was advised that the intervener was a vulnerable individual in his own right. He had attended a special needs school. and he had a learning disability, and that was accepted by all parties. He had overcome that to secure good employment, working 7 days a week, 12 hours a day, with generally a 5 o'clock in the morning start time. He was of nervous disposition, and he suffered terribly with his anxiety. So much so that I asked him before he gave his evidence to address to the court how his anxiety would manifest itself. And he said that he would smile, he would grin nervously, and he had expressed concern that this was going to happen during the course of his evidence. And the reason why I asked him to address the court in respect of that is because during the course of my conference with him, this is what I had observed, and having made further inquiries, this information became apparent. The court was also invited to note that he had a nervous squint, and that would manifest itself with a shaking of the head and twitching his eye. That was really important for the court to consider, but unfortunately it hasn't reached the judgment. And so
were all these points made to the judge?
They were, and my lord, what I'm reading from is my written submission to the judge, asking her to consider the fact that he presented as a vulnerable man in his own right. He attended a special educational needs school, suffered with a learning disability, overcame that. I won't repeat what I've just said to my lord. And the fact how his mannerisms came out. So not only was it set out at the beginning of the hearing, it was repeated in the written submissions. So whilst she has found him to be open and credible, she has not gone on to establish what part of his evidence he was lying about, not open or truthful about, and neither has, and she has also failed to consider his own vulnerabilities when giving his evidence, and that is absolutely vital that she should have done so. The intervener was not legally aided. He funded his own representation effectively by his parents, but there was part of the case where I acted pro bono, and it's as a result of that that the intervener fully adopts the submissions made on behalf of the appellant mother, and has not made his own appeal, albeit he did seek permission to appeal, but given the costs involved, he has adopted the submissions made by the
Yes.
mother. During his evidence, he presented as dutiful, observing his obligations to the family, and also the taking of the children to and from school, taking the mother to and from the market, and he was very observant to the close family dynamics, and that was identified by the judge. I submitted that his evidence overall was generally honest, and that was despite the fact that he knew his evidence would upset the mother, the stepmother and the father, and it did. He was very honest in respect of that. Unfortunately, and words were, when asked about how he felt about being made an intervener in these proceedings, his words were, "I feel like I've been thrown under a bus." He, at no time, called anybody a liar. He didn't embellish his evidence. And indeed, he actually extended the length of time he was on his own in the car from what I think was submitted initially, 5 minutes, to 20 minutes. It's unfortunate that the judge did not recognise any of the positives in respect of the intervener to identify what part of evidence he was lying about. And again, I repeat the fact that she found him generally open and credible. Also telling, in the core bundle, at A243, sorry, A245.
Paragraph 23.
Yes, when considering allegation 28, if I could invite you, my lord, to look at 23A.
Yeah.
The parents have not been open or honest with professionals or the court about factual information within their knowledge as to how Ibrahim sustained a serious fracture. B. The parents and Aqib deliberately withheld relevant information as to how child sustained a skull fracture whilst at times discussing it with the family. There is a clear, deliberate point that she has missed off the intervener at point A and added the intervener into point B. Also, at A154, paragraph 13, third line from the bottom, and this is where there is the general Lucas direction applied. The parents have not been truthful with professionals from their first contact at hospital. A reasonable parent would provide relevant information within their knowledge about an injury to a child. The parents did not do so. Again, there is no identification to the...
He's not mentioned in that
Not
paragraph.
at all. And indeed, throughout the judgment, a general sweeping submission is that he wasn't mentioned throughout the judgment. Merely he was mentioned as an adult. None of the adults have been telling the truth. It was incumbent upon the judge to identify what part of the intervener's evidence she was troubled with, and she has failed to do so. When applying the Lucas direction, the court will be reminded that an individual lies for many reasons, and that includes fear, anxiety and distress. And clearly in this particular instance, given the fact that the intervener was vulnerable in his own right, she has failed to apply the Lucas direction in relation to that either. So
You say he wasn't lying. I mean, that's a different point, isn't it? You say you should have given him credit for what he did.
Yes. I'm submitting that he was not lying, and the judge invariably found him credible, open and credible. And so I'm inviting this court to consider, whilst considering the appeal on behalf of the mother, also consider the intervener in that regard.
I'm just wondering where your point about his vulnerabilities fits into that, because this isn't a case where the judge has said, I didn't like the way he behaved in the witness box. She hasn't explicitly based her rejection of his evidence on his demeanour. If she'd done that, I could see absolutely the force of your point about his presentation.
Well, we don't know whether she has or not, my lord, because quite simply she hasn't identified the manner in which he gave evidence. What she has identified is that he gave evidence in an open and credible way.
Well, quite. So that means she hasn't taken account of any nervous tics that he may have exhibited. What she seems to have said is that it was the content of his evidence that didn't satisfy her, not the manner in which he gave it.
But again, it's just not identified as to what part of his
No,
evidence.
but that's a separate point, isn't it, really?
Yes,
The way I read it, she said he presented well, it looked credible,
yes,
but it wasn't.
yes,
For some reason that you say she hasn't explained why.
yes.
Yeah.
My lord, unless I can assist any further.
Anything else? Thank you very much. Now, Mr. Goodwin.
My Lord, may I preface these submissions with some general observations? The first of which is that this was not a complex case for a circuit judge. It's a single injury, infant skull fracture, likes of which come before judges of the family court week in, week out. The judge was confronted, as is often the case, with what I've called in my skeleton argument a wall of silence. I suppose that's not sufficiently nuanced in the sense that there was silence about the truth, as found by the judge, but there were a number of other explanations given, in fact multiple explanations given by the three adults, which the judge found didn't wash. And the judge was therefore not assisted in any shape or form in trying to get to the bottom of what had actually happened to IB so as to cause his skull fracture. The judge was, in my submission, very careful indeed not to speculate and to fall into the trap of speculating about what might have happened with him. And so she ended up with these two broad conclusions about inflicted injury on one count and deficient accident, culpable accident on another. My Lord, I don't mean to be glib when I say this. Many circuit judges would just have found that this child had suffered an inflicted injury here on these facts. But what this judge did, in my submission, in finding culpable accident, was to be fair to the three adults, because she was importing into her overall analysis and conclusions a possibility of an injury that was not inflicted, which was not necessarily an area into which she had to go, but she chose to do that in recognition primarily of the lack of help she had had from everybody about the true causation. My Lord, I accept it on paper, I accept it now, that she has not, the judge has not in some ways helped herself because she has been overcomplicated in her analysis, one might say. Your Lordship's opening observations this morning about the convoluted procedural history by which the judgment in its various iterations emanated, I have absolutely no difficulty with that adjective.
No. Do you accept what Miss Mayor has said to us, that some passages, including, it seems, some important passages in the clarification document, were not in the original draft and only appeared in the version ultimately handed
The learned
down?
friend's opening analysis of the sequence of judgments and clarifications is absolutely accurate. I have no difficulty with that. It is correct that the two references to deficient parenting come in the second iteration of the clarification document, Annex 1.
So the two references to deficient parenting come in the iteration that was handed down on the 10th of August,
That's right.
after the permission to appeal arguments had been ventilated.
So, obviously, one of the issues that this court will be considering is whether, as my learned friend argues, the reference to deficient parenting is an afterthought. It's put quite high by my learned friend in the sense that I think plug the gap was used as an expression colloquially. It's used retrospectively and impermissibly to plug the gap when the judge's original analysis was in itself deficient, whereas I say, on the other side of that argument, that the way the judge articulated her original decision was deficient, but once she had the opportunity to clarify her thinking, not to revisit her thinking, but to clarify her thinking, she set out in black and white in Annex 1 what she had meant by accident was an accident that in itself would satisfy Section 31 because it was as a result of culpable or deficient parenting.
So you say we should not be unduly concerned that it took several goes at clarification before it was clarified?
I do. Advocates, as this court very well knows, are encouraged from the highest level to submit these clarification responses.
Yes, they are. Well,
Well, to some
Well,
extent.
when you put it, that's putting it quite high.
Okay.
Encouraged at the highest level.
Yeah.
It suggests.
Well,
They're discouraged
They're
from waiting, from making that point to the Court of Appeal if they haven't made it
that's
to the
what
judge.
I meant, my lord.
They are.
That's what I meant. Thank you.
Yeah.
I mean, all
Can
those-
I ask a question about the procedural history? One of the reasons that it's possible to invite us to infer that the judge had further thoughts that she hadn't had before is that she was receiving permission to appeal applications before she's handed down the judgment. And that's, to me, a bit of a novelty. Is that something that is a common practice?
No, not at all.
No.
No, I'm glad your lordship refers to common practice. So, answer one is that I've never seen that before, and it's not common practice. The second answer, in response to I think the point raised by my Lady Justice Whipple before, is that the process of clarification requests and judicial responses are common.
Yes.
Normally the clarification request becomes a free-floating document, but in this case the judge has collated all these annexes, including Annex 1, the clarification response, in a way that is unusual, but in my submission does not detract in any shape or form from the integrity of the decision.
Okay. So, my Lord asked about, is it common to put a PTA application in before hand down? Answer, no. Is it common for the clarification, the request for further reasons to be submitted before the judgment's been handed down?
I have seen that before.
Have you?
I think that's what English and Emery Reinbold
Does it?
suggests, doesn't it?
No, we haven't got English. I'm look, see what that's. We might. We're not going to be going after. We'll look at English and Emery Reinbold. I mean, I can remember when this was all started, Mr. Goodwin, when the re-being case in front of Lord Justice thought possibly in this very court. I was here with Mr. Keane, Mr. Hirschman, and others.
Yes.
And it's grown as a practice. It's in almost every case, or certainly a lot of cases, isn't it? I mean, shouldn't it really be the case that you don't ask for clarification until the judgment's handed down?
Absolutely. I agree. And Lord Justice Warby is right that the Court of Appeal doesn't encourage clarification. It encourages advocates on submitting clarification responses rather than taking a bad point on appeal at a subsequent time. And in this case, the submission of clarification requests was entirely legitimate. The judge's response to those requests was legitimate. There's nothing odd about the fact she put them in a separate appendix to the judgment. The point of these clarification requests is that the Court of Appeal, if asked to consider the integrity of the first instance decision, looks at the totality of the documentation. If you're going to submit a clarification request, get the response from the judge, and then hold the judge to what the original judgment said, without regard to the clarification request, what's the point of the clarification request?
I'm just looking at English and Emery Reinbold, and we can look at it in more detail later, but the headnote says, if an application for permission to appeal on the ground of lack of reasons is made to the trial judge, the judge should consider whether the judgment is defective for lack of reasons, adjourning if necessary. And then if the judge concludes it is, they should set out to remedy the defect by providing additional reasons. So the suggestion there is it's all done in the context of a permission to appeal application which follows the handing down of an allegedly defective judgment. So
I see that, my lord.
That seems to be the.
I think the practice.
My lord is right about that.
The practice. I mean, I think there's been a slight evolution. I don't think you have to wait to file a PTA application. I mean, you don't. They don't. But that's the origin of it. So it definitely all this follows the handing down of judgment.
Yes, and what it's done, having it before judgment is handed down initially, overcomplicates it because it adds another layer of judicial thinking in a process that should have been judgment hand down, clarification request, final response. So I repeat, I think my view is that the judge has overcomplicated the structure of her judgment and the clarification response, but ultimately that is not at the price of the overall integrity of the judgment.
As long as we could be satisfied that the things that she clarified were things that she thought but perhaps had not articulated fully. The danger is of reverse engineering.
Yes.
And that, no doubt, is why earlier this morning, one of your lordships or ladyship asked learned friend where the judgment disclosed anything in support of the suggestion that she had reverse engineered the point, and there is nothing in the judgment to suggest that. As a separate point, before I forget it, your lordship touched on the practice of separate legal annexes, and Lady Justice King has very recently opined on that in Re A 2022 EWCA Civ 1348. REA 2022 EWCA Civ 1348 paragraph 11.
What's she say?
She says don't do it.
Well, I'm glad that we're on the same page. You know.
Well, she says, I mean, it's a very short reference here. I appreciate the value of a document to a busy circuit judge, but a measure of circumspection is necessary. And the basic point is that by having it as the risk is that it's a bolt-on and it's not incorporated into the fabric of the reasoning. Yes.
But there weren't 7 in that case as well, I expect.
7?
7. There weren't 7 annexes in Justice King's case.
Well, that might be a little bit unfair, my lord, because the bolt-on legal principle document is but one of 7, and there are different...
she's talking about the legal principle.
She's only talking about legal
Okay,
principle.
right.
Yeah.
Sorry. Okay.
And some of the annexes really stand as separate
They do.
rulings. I mean, the ruling on permission to appeal would normally just be a judgment.
I've never seen 7 annexes before, or indeed a judge annexing any of the
But it's
categories of document.
It may be a reflection of the fact that this all happened at once. I mean, it's all back to front. The judgment should have been handed down first, and then you get, as you said, the permission and the clarification. Okay, all right.
But, my lord, before I move on, if I may, there is, of course, no appeal by the intervener before the court. So I find myself listening...
Well, we allowed Miss Atwood to address us, but
I'll move on from that. I had expected to find myself on my feet this morning defending the judge's in-principle decision to have, on one side of the Section 31 offence, inflicted injury and a culpable accident on the other. But it appears from Learned Friend's submissions, and I'm grateful, if I'm right, to her for the concession, that that is no longer an argument I am facing. It is not being said that the judge's essential formulation is wrong in law.
yeah.
Your Lordship has all my arguments on paper in that respect, but to supplement them only by bullet points, I would only say look at the language of Section 31 and what it in fact requires the court to do. It has to be satisfied that the child suffered harm, or that there was a likelihood the child would suffer harm, and the court has to be satisfied about what has come to be known as the attributability condition within Section 31, namely that the harm or likelihood of harm is attributable to unreasonable parental or unreasonable care. The judge has done that here. The empirical finding of fact in relation to Part A, Child IB, the empirical finding of fact is that he suffered a skull fracture as a result of an impact, a single impact against a hard surface, attributable to unreasonable parental care. That is the key finding. That finding, taken as I say it in its purest form, does not mean this judge sat on the fence, which is what's alleged. And although the first iteration of the judgment didn't specify that the second part of the equation was deficient parenting, the past muster point, the clarification response, put that beyond argument in my submission. The final point I wanted to make about this in-principle legal argument in relation to inflicted injury versus culpable accident, it's another way of expressing the same point, I suppose, but where mechanism A, as I put it on paper, and mechanism B would each individually be sufficient to satisfy Section 31, and if the group of possibilities is closed, and I emphasise closed as it is here, so inflicted injury and culpable accident are the only 2 members of that closed group, the judge has seen off the possibility of a benign accident, non-culpable accident. That's not part of the closed group. So a conclusion that mechanism A or mechanism B are possible causative scenarios is sufficient to meet Section 31 because the group is closed. There is no conflation here with the uncertain perpetrator test in Re B 2019. I don't have the rest of the citation, I'm afraid. That is, of course, the Court of Appeal case in which Lord Justice Peter Jackson said that to be included in a pool of perpetrators, there had to be a real possibility or likelihood
Different point.
established. It's a different point, but it's one of the points I face. The inflicted injury thesis and the culpable accident thesis here are only possibilities in the alternative to each other. They are not possibilities in the alternative to a non-Section 31 causation, because it's a closed field.
What do you say to Miss Mayer's point that on inflicted injury it wasn't open to? Well, you did say it wasn't open to the judge, which the judge did in fact make a finding.
I say with respect that that puts the submission extremely high. The expert evidence was that this was a skull fracture that was either caused accidentally or the result of an inflicted injury. The medics could not say from the x-ray and the appearance of the skull with the underlying hematoma whether it was caused with intent, inflicted injury, or whether it was the result of a culpable accident. Of course the medics couldn't say that, but the judge was entitled, we say, in the context of the lies that she was told by all three adults, to make a finding that this was either an inflicted injury or a culpable accident. Why else, she reasoned with herself, would she have been told so many lies on so many occasions by three different people? So I would suggest this court should be extraordinarily slow to interfere with the conclusion that an inflicted injury is one of two differential possibilities alongside culpable accident.
Right.
But Lord, can I move on from that and just address the court briefly about the argument in relation to the inversion of the burden of proof?
Yes, this is how is it paragraph 12 on
PDF 156A154.
yes. In the clarification document. Now, my lady and I reached a preliminary different view as to whether accident in line 4 was culpable or general. Where do you?
I'm not sure it makes any difference, is my answer to that.
Sitting on the fence.
Thank you, Lord. The reason I say it doesn't make any difference derives in part from one of the preceding pages, which is paragraph 9 at 151.
Okay.
And we see there in starkest terms, in the first line of paragraph 9, the parents and the intervener had no obligation to prove anything. The burden was on the local authority.
Okay. So right.
We invite you to read this judgment as a whole.
So which paragraph is that?
That's
9.
opening line of
of the
paragraph 9 on
clarification.
151.
For clarification, sorry.
A151, PDF
Yeah.
153.
So you say that knocks on the head the argument.
So that knocks it on the head, but going back in any event to paragraph 12 of the clarification response at A154, what does the judge actually say? I've not been able to conclude which of the three adults deliberately inflicted the injury, if that occurred. Quite an appropriate caveat, because the adults have not been honest about their knowledge of the circumstances surrounding the cause of the injury, nor how it occurred for the same reason. So that must follow from the rest of the judgment, what she's found. Nor can I rule out the possibility that the injury occurred as a result of an accident. That must be right, and that sits with her conclusion that a culpable accident is an alternative causation. I could not make a finding that that was so on the balance of probabilities, because the adults have not been honest about their knowledge of the circumstances surrounding the cause of the injury and the evidence I heard. All the judge is saying there, my lord, is that she's not been able to make a civil standard finding that this was an accident. That's what she said 100 times in other places. It doesn't mean that she's inverted the burden of proof and decided that the adults had themselves to prove that there was an accident if they were to knock the local authorities' case on Section 31 out of kilter. So paragraph 12 should be read in the context of paragraph 9. And everything else that the judge said on other occasions about the local authority having proved its case on points X, Y, and Z. I don't know whether I need to address this court in relation to the Lucas analysis and to provide the references in relation to that.
Well, would you like to give us some bullet points on that?
The bullet points are, first of all, at page A113, PDF 115, paragraph 16 of the judgment. The judge analyses how the adult witnesses, and all three of them, were not able or willing to be open and truthful about matters relevant to the circumstances in which the child sustained a skull fracture. So there's a global finding there, an all-encompassing finding at the start of paragraph 16, that none of them was willing to tell the truth. Then there's recorded at paragraph 17 an observation about the manner in which both parents have given evidence, not being actively willing to assist the court. And the judge returns at a later stage in her judgment to her final conclusions about the quality and integrity of the evidence given by all three.
In paragraph...
So that...
81?
Well, I was going to say 86, but 86 is the section on the adult witnesses' oral evidence.
86 and following.
86 and following.
Okay.
But if we go back to paragraph 17, going back to the Lucas point, so this is page A113, PDF 115. The judge, over the page on 114, gives herself the Lucas direction in an appropriate way. There are very many reasons why a witness may not be truthful. It's not the court's role to speculate, to fill in gaps in the evidence. So that's the first time she gives herself the Lucas direction, but it's not the last, in the sense that we go to the first annex at page A151, PDF 153. And the court will see in the middle of paragraph 9, the judge asks herself why those involved or with knowledge about it, it being a hypothetical accident, chose to hide that fact. She's asking herself why there were lies told to her. And she says that it could be, the explanation could lie in feelings of shame, fear, misplaced loyalty, etc. It could be because the shame or fear is of disclosing a more serious incident. And she returns to that self-direction a few pages on at page A154, PDF 156. In paragraph 13, at the bottom of that page, applying a Lucas direction in this case has been particularly important. The family dynamics are complex. There are, in my judgment, many reasons why in this case the adult family members may have lied. Fear of the truth, misplaced sense of loyalty, torn loyalties being some examples only. So, in my submission, Lord, you have the judge on at least 3 separate occasions directing herself in the terms of Lucas in an entirely appropriate way. It's quite clear, this is a matter for this court, of course, but it's quite clear that she had well in mind the possibility that lies were being told to conceal a culpable accident. as much as lies might have been told, to conceal an inflicted injury. She repeatedly referred to it. So this is not, in fact, a case in which one finds the Lucas direction only isolated in a subsequent annex to the judgment, which summarises the advocate's take on the law. On this point, it's there in the judgment on 3 separate occasions, the judgment and the clarification document.
So what is the finding? Is the finding that it's a real possibility that one or other of these causes led to the injury, or is the finding that on the balance of probabilities, it's one or the other, but you can't tell which?
The finding is on the balance of probability. The child suffered a skull fracture as a result of one or the other.
Yes.
But within that closed field, there's a possibility that it's A or B.
Yes, because obviously there'd be some room for debate about whether a real possibility was enough if it wasn't probable that one or the other was.
Well, that comes back to the submissions I was making
Yes.
before, my lord, in which I've said that if there's a closed field, as there is here, there is no room for any conclusion other than, on a civil standard, the child suffered significant harm, the skull fracture was caused by unreasonable parental care. That is the key point, and it matters not, we say, and I believe it's now conceded, that the 2 differential causations are only possibilities as regards one or each other. But anyway, my lord, I repeat myself.
Well, I mean, it's not, if it's a closed field, then it's one or the other, and the judge is unable to say which.
Exactly.
Yeah.
Should I take it that your lordship is troubled by that point?
No. I just it's not that both are a real possibility. Therefore, the judge can't say which is probable. It's that the judge can't say which is probable because in all the circumstances, including the parent's lack of honesty. All right. So does that do where that I think that
So
deals
that
with
deals
Lucas
with the burden of proof
and Lucas.
And Lucas. I think I probably need not address the court about failure to seek medical attention for the child, because that was based on the paediatrician's observations, and there was plenty of evidence about the boggy swelling, etc. So I won't go into that. There's an argument about the failure to protect and whether the judge contradicted herself by saying that she had not made a finding of failure to protect.
What she said was she was unable to make a finding of failure to protect because of the given her findings about the principal findings about the injury, she couldn't make a finding about failure to protect.
Totally.
Yeah. Okay.
But it went on that sentence, didn't it? And as I understood it, what she was saying, but nor am I making a positive finding that they did protect.
Exactly.
It's a not proven. So
That's
Scott's
exactly the
not
point.
proven.
Okay. All right.
Yeah. And if it's necessary, I rely on Lord Justice Mumby's decision, as he then was in Rie, a child number 2, 2011 EWCA Civ 12, Rie number 2, 2011 EWCA Civ 12. It may be relevant at the subsequent welfare hearing to know, and thus for the judge as part of his fact-finding to record whether a particular matter was not found proved because the judge was satisfied as a matter of fact it didn't happen, or whether it was not found proved. It's your ladyship's point in a previous Court of Appeal.
Yeah. Okay.
My lord, I think that only leaves
Part
the Part B position. And I start, my lord, by asking this court to stand back from the facts that the judge had found as a result of her Part A analysis. She had concluded that there was an unexplained skull fracture caused by unreasonable parenting, and she was being told nothing about the true circumstances in which that injury was sustained. Stepping back, in my submission, the judge was entitled to find Section 31 met in respect of the older children. It would be odd in the extreme to rule that a judge could not find Section 31 met because 3 adults who knew how a child had been hurt had chosen not to say, in circumstances where, if the skull fracture was caused as a result of deliberate violence, loss of temper, a child being hit over the head with a hard object, or a child's head being hit onto a hard object, and I'm sorry to be visceral about it, but that is what underlay the judge's decision in relation to the other children. If that was the cause of this skull fracture, of course the judge was entitled to conclude that there was a likelihood of significant harm in each of their respects, irrespective of whether the other children were 4, 7 or 16. I'll come on in a moment to what.
Well, is that the right approach? So when you're looking at the likelihood of harm to another child, what is the factual finding upon which you have to base your assessment of real possibility with respect to the other child?
The judge dealt with it by acknowledging that there were potentially different bases on which the likelihood of harm to the older children might arise. It might arise because of an inflicted injury. It might arise because of a culpable accident. But the judge should not be penalised. She should not be held to have backed herself into a corner on the culpable accident point simply because she had widened the causative possibilities for the skull fracture. I appreciate there is the argument that if the skull fracture was caused as a result of a culpable accident that might only arise with an infant, for example, let's say, and I create this example myself, let's say that one is walking down the stairs with an infant in arms, having drunk a bottle of vodka. That's a culpable accident that is likely to put an infant at risk, but less likely to put a 16-year-old at risk.
Okay.
But the judge should not be penalised as such for reaching a conclusion in relation to section 31 on the older children that encompassed both inflicted injury and accident simply because she hadn't been able to define exactly how the injury had been caused. So
well, now, just a moment. Your argument on... I follow your argument about there being a closed category
Yes.
of causes for the head injury to IB. But can you rely on that same closed category in respect of the finding of significant harm, likelihood of significant harm for the other children? Or don't you have to, doesn't the fact the judge was unable to distinguish between inflicted and culpable accident mean that she couldn't just rely on that finding as the finding is the way you postulated it, as giving rise to a likelihood of significant harm?
The judge addressed that in this way. The judge found, as the foundation for her conclusion that the older children were likely to suffer significant harm, that it was, quote, not possible to protect against the recurrence of injury. That's in the judgment at paragraph 103 on A140, PDF 142.
Say again, sorry.
It's at paragraph 103,
Okay.
A140, PDF 142.
Okay.
The parents and the intervener have not been open and honest about their knowledge of relevant events. In the circumstances of this case and the evidence in it, it is not possible to take steps to protect against a reoccurrence of a significant injury occurring in the future in a similar way to IB or one of his young siblings. The issue is more complex in respect of the older children.
So is that her reasoning for the finding 17 we see on A243?
Is this finding 17 of the findings proved?
Yes, the findings proved. The finding in the findings document appended to the judgment.
Yeah.
In annex, whichever it is.
A208.
Hmm?
Is that A208?
No, 2443. So this is annex 6. Allegations proved by the local authority.
I see that, yeah.
And what I said, the judge makes two findings of significance in respect to the likelihood of the older children suffering significant harm. One at 17 and one at 24. At 17, she says, by reason of the matters set out above. So that is solely the circumstances of IB's head injury.
Yep.
And the findings are made about that. And my question to you is if we're looking for the reasons for that, which we were looking at with Miss Mayer, are you saying that it's what she said at 103 to 105 of the judgment? That is the reason rationale for that.
I say that the following proven facts are the legitimate foundation for that paragraph 17 finding in relation to the older children.
Okay.
First of all, allegation 23. The mother refused further police involvement
Well,
after reporting the father was violent to her in front of the children.
yes. Well, this is my point. That the judge makes two findings of the basis of two findings of likelihood of significant harm with respect to the older children. One at paragraph 17, which is focused on IB's injuries, and the other at paragraph 24, which includes everything, including IB's injuries.
Yeah.
So
This court, in my submission, should stand back and look at the totality of the reasoning and the underlying foundations of fact before reaching a conclusion that the Section 31 determination for the older children is not legitimate.
well, I mean, yeah.
I mean, that, in my submission, that
So,
must be right.
I mean, you're saying we could find that her ultimate conclusion, paragraph 24, based on everything in the threshold document, the findings,
Yes.
summary findings, including the Part B findings,
absolutely.
is sufficient.
Yes.
And we shouldn't be worried about what's said in 17, which is that there's a likelihood of significant harm to the older children simply as a result of the circumstances of IB's injury.
This is one of those cases where your lordships and your ladyship are able to reach that conclusion based on the totality of the evidence.
Okay.
Remission to another judge to decide that Section 31 argument is unnecessary, let alone disproportionate. It's unnecessary. I wanted to bullet point for the court what the foundations were overall for the judge's conclusion in relation to the older children.
Okay, well, I put a version of that to Miss Mayer
Yeah.
from my reading. Do you want to say what you think?
If I may. So there's the allegation 23 finding, which is proven that the mother refused further police involvement after reporting the father was violent. The reference to that, and I'm not going to take you to it unless you wish me to, I'll just give you the references.
Okay.
The references is allegation 23, A243, PDF 245.
That's the judgment, isn't it? That's clarification.
That's the findings.
Sorry, you're right. Findings, yes.
That's the findings proven document.
Yes.
And that, of course, is where the judge also says that the parents do not have a clear understanding of domestic abuse.
Yes.
Another point your lordship put to me
Yeah.
friend. We then get all the way through the allegation 19 to 26 findings that the judge did not find proven.
This is what's set out in our findings document on A244
Yeah.
at paragraph 20 and 21
Exactly.
and 22.
And we come to allegation
And
28.
do you agree with me? They I'm not sure why 20 to 22 were there, really. They're not. If she's sitting out of
I
findings,
agree.
these are not findings.
I agree.
Okay.
Well, perhaps to guard against a submission of the kind that we've been entertained with this morning, to make clear that she had not factored in any adverse conclusions on those topics.
She was at pains to say that on a number of occasions.
Okay, so
then
we get to
come
23.
We then come to allegation 28.
Yes, which is dealt with at 23 of the findings document
Yeah.
on
So this is an
245.
encouragement or cultivation of an understanding within the family, on occasions enforced by the older and adult siblings, that professionals or the authorities are not to be told the truth about the physical assaults. Bullet points. First of all, the judge again emphasises that she's not made a finding on the basis of the historical allegations. That's it. The judgment, paragraph 116, A143. Second, the judge finds again that the parents have not been honest and open about the skull fracture and have deliberately withheld information. Judgment, paragraph 117, A144. And there's a separate finding on that front that the parents and the intervener have deliberately withheld information in the schedule at A245.
Yeah.
It's then expressed again in the Annex 6 document,
That's what we're looking at.
A245,
Yes.
as well as the judgment, paragraph 117 at A144. 117 at A144.
Yes.
Understanding in the household that difficult issues are addressed as a family first, even if that means professionals are given misleading
Yes.
accounts.
These are
And
really
then-
the point. These are all the points I put to Ms.
I'm sure they are. I didn't know whether these are sub-particulars, my lord. I'm not suggesting they weren't.
No,
But I just
okay.
want to make sure we're on the same page, as I am sure we are. And then finally, the schedule of facts, Annex 6, A245, the parents did not have adequate regard to the direct and indirect repercussions of misleading professionals about the children. I don't know whether this helps, but just delving slightly deeper into the factual evidence that the judge had, there were two occasions. One in which the mother, the father, and the intervener said they had discussed the events of the 7th of May first before telling professionals about it on the 11th. There's a typo because the judge says the 11th of March. It should be the 11th of May. That reference is at paragraph 87 of the judgment, A136. So that's prior familial discussion before telling professionals. And then the second point is that the father told the mother not to say anything to anyone about the swelling, and they would discuss it later. That is a supplemental bundle C38, PDF 227. The other factual foundation...
Sorry, just get that reference again.
Supplemental bundle C38, PDF 227. Father saying to the mother, don't say anything to anybody about the swelling, we'll discuss it later. And then finally, as indeed your lordship says, one has the slapping of R, 18A, allegation 18A. One has the DV incident in front of the children, allegation 18B. And on a lower level, the finding of significant verbal arguments between the children as accepted by the mother, allegation 30.
And the minimisation and not the points made in finding 19 on 243. Yes, okay.
I know reference has been made by the learned friend to a case called Re SB,
Yes.
which is a case in which the Supreme Court, House of Lords, I think it was.
Wasn't it post 2009?
No, it was Supreme Court actually. It was 2009.
Yes, it was. Oh, well, was it? It was
2000, it's 2009 UK. Oh, it's UKSC 17. It is Supreme Court. In that case, the Supreme Court emphasised that
we've got it, haven't we?
we've got it in the authorities.
We have.
It's at
This
page
is
97, PDF 98 of the authorities bundle.
this is yes. I remember.
So just
I remember hearing about this case.
So, my lord, just to summarise this case.
Yes.
One of the points that is relied upon by my learned friend is that where a child is injured by one of two carers,
Yeah.
and the court makes a pool of perpetrator finding, unable to specify who caused the injury, if those two carers split up and let's say, for the sake of argument, the mother then goes on to have another relationship and another child, one can't use the fact that there was a real possibility she had injured the first child as a threshold ground against her in care proceedings brought in respect of her new child, because a finding of real possibility is insufficient to meet the threshold. It's an insufficient foundation for a finding of likelihood of future harm. That, however, is not this case. The main reason it's not this case is because in this case, the family cohort is as it was. No one's gone off to have a different relationship, another relationship with another child born.
That situation might arise if the family did split up, and it could only be said of any one of these three
absolutely
possible perpetrators.
And that will always follow from
real
pool
possibility.
finding. But of course, the Supreme Court makes the observation that very often pool findings in terms of perpetration are accompanied by findings of failure to protect and other findings to the civil standard, which will follow the adult or the parent around into a new relationship. So it's not that Section 31 can never be considered or met when somebody moves on into a new relationship. But in my submission, the re-SB argument does not really assist this court on the facts of this case. So, my Lord, drawing these submissions to a close, subject to anything the court wishes to ask me, in essence, in relation to Part B, I make 2 points. First, the judge was at pains to say she made no findings at all in relation to the allegations, the historical allegations, and she did not factor them in to her analysis. Whatever the merits of that case management decision that she made were, and she made that decision in order to allow herself to survey the broadest canvas of evidence when it came to the fact-finding hearing, she then scrupulously avoided falling into a trap that she might otherwise have set herself by attaching any weight to any of the historic allegations. That's the first point. Second point is, as we have already discussed, this court is not only entitled to, but should stand back and look at the totality of the judgment before reaching the conclusion that the Section 31 finding in relation to the older children was impermissible. In my submission, it was within the judge's reach. She adequately reasoned it. Perhaps she could have said more, but that is not what the appellate exercise should necessarily be about. My Lord, can I assist any further at this stage?
Thank you very much, Mr. Gilbert.
Thank you, my Lord.
Ms. Mayor.
My Lord, I think only one matter, simply by way of completeness, and this was in the consideration at the judgment in A140 of the extrapolation of the risk of physical harm to the elder children and to the paragraphs that you have there at 103, 104 and 105.
Yes.
Paragraph 104, she having commented in the preceding paragraph in relation to IB's young siblings, raised herself that the issue is more complex in respect of the older children, H and R, given their ages in the light of the conclusions that she's reached above. We dealt with this in paragraphs, I think it's in total 63 through to 65 of our skeleton argument. She doesn't in fact come back to explain how she therefore deals with that complexity in 104 and how she transposes that risk of physical harm to the older children. We've obviously heard the description given by my learned friend in relation to the various potential inflicted injury explanations, of course none of which were rehearsed by the judge at any point when she considered leaving inflicted injury in as one of two findings. And I think the only other matter that I would perhaps demur about in the way that it's been explained is whilst the principle of a closed set of only two possible explanations, we didn't accept a closed set of only two explanations in relation to this particular case. So the idea of it's either inflicted or culpable injury, we obviously still left open. Culpable accident. We obviously still left open the non-culpable accident. And I think the only other point in relation to the sequence of the judgments is, whilst you're asked to step back and look at the totality in relation to the August judgment, we know that the judge was operating effectively on the 30th of June judgment at the time that she came to deal with the younger child, the new baby, because those interim care orders and decisions over placement were made way before the 10th of August judgment was available. Unless there's anything I can assist you on.
Let me just make a note of that. Yeah. All right. I'm just thinking now about, well, obviously we're going to reserve judgment in this case. We won't be handing down judgment before the start of next term. And that means, Mr. Goodwin, that the local authority will have to put its evidence in. Is there anything you can say about local authority's position, or is it too early to say?
I would have to take detailed instructions on that, and I feel I won't be able to do that on my feet now.
No, quite, okay. So local authority will have to proceed and file its evidence on the 6th of January, even though, if we allow the appeal,
but if the appeal is allowed, I suppose if I put it this way, that will derail the process and timetabling.
it will.
In a way that would be unavoidable.
It would, I'm afraid, because perhaps I should ask you this: if the appeal is allowed, what do you say the court should do? Remit for rehearing?
The court would have to.
Yeah. Okay. Well, that would be an unavoidable conclusion if we allowed the appeal, and I think the local authority is going to file its evidence on the basis of this timetable, and we will endeavour to hand our judgment down very soon after the beginning of next term. But that means either the week of the the 9th, so this latter part of the week of the 9th, or the following week.
Yes. And if that necessitates further re-timetabling application to the first instance, I'll have
Well,
to
that's
take that
what it will
course.
have to be, yes. Thank you very much. Anything else you want to say? No. Well, thank you both very much.
Can I just say, for the avoidance of doubt, that the intervener was discharged as an intervener?
Okay, thank you very much.
Just appeal that he remains.
All right. Obviously, if there was a rehearing, he would have to come back in. We will reserve judgment in this case, I've already indicated. We're very grateful to you for your helpful submissions, both in writing and orally today. We won't be able to give our judgment before we break for the Christmas vacation. We will hand down judgment as soon as possible after the start of next term. The judgment will be set out in draft to council for any typographical corrections or minor factual errors to be pointed out. It's not an opportunity, of course, to re-argue the appeal. You will know of the recent unfortunate examples of judgments, confidential draft judgments being disclosed, and the warning in the Council General of Wales case of the consequences of that. I hope very much that won't be a problem in this case, but I ask you to bear that in mind. When you get our judgment, draft judgment, we'd be grateful if you would consider what the consequential orders would be and agree those matters if you can. If you're unable to agree, then please put forward brief written submissions and we will determine those ancillary issues on paper. And we hope to hand down the order with the judgment when the judgment is finally handed down in due course. Thank you very much.
Thank you, Lord.
Lord,